Budholia, partner AZB and Partners, and Mr. Jeremy Robinson, partner Gibson Dunn. Requesting our panelists to please join us on the stage and to very briefly introduce you to our panel. Thank you. If I may have your attention, please. We already have the panelists on the stage. Can we have everyone be seated now? We have already started our next session. Thank you. We promise you more time for networking. Thank you. Just to very briefly introduce you to our panel, ladies and gentlemen, we have with us as the session chair Ms. Jyoti Bhanot, Advisor and Secretary, Competition Commission of India, and she holds a bachelor's degree in economics as well as a master's degree in business economics from the Delhi University. She possesses a vast regulatory and enforcement experience as a part, she's been a part of various domestic and international committees and think tanks. Is presently heading one of the antitrust divisions at the CCI, and before her current role at the Competition Commission of India, she's worked as the Additional Director General for about 5 years in the Office of the Director General, Competition Commission of India. Earlier, she's worked for around 15 years in SEBI and the regulator for the securities market in India in various capacities in different areas. We'd like to welcome Ms. Bhanot. I'm going to request the session moderator, Mr. Sagardeep Rathi, to kindly present a plant sapling on behalf of all of us here to Ms. Jyoti Bhanot, the session chair, and welcome her. Thank you. And to also very briefly introduce our session moderator, ladies and gentlemen, Mr. Sagardeep Rathi is a partner with Khaitan and Company and the antitrust practice group in the New Delhi office. He regularly advises clients on a variety of competition law issues on agreements, abuse of dominance, and merger control filings in various sectors. He's also actively involved in conducting competition compliance trainings for clients in diverse sectors. Sagardeep also has extensive experience in relation to leniency applications filed at the Competition Commission of India and in assisting clients in dawn raids. So without any further ado, I'm going to hand it over to you, Mr. Rathi, to take the session forward from here.
Thank you for that introduction. Good morning, everyone. Sorry, I have a bad throat, so maybe I'm not sounding so well, but thank you to ASSOCHAM for organizing this conference, and it, of course, as we all heard in the inaugural session, I think it's a very timely discussion on various issues surrounding how the CCI has come so far. I think the theme of the conference is the past, present, and the future. We've, in the inaugural session, heard about how the CCI came about starting from 2000, 2002 until today, and what lies in the future with the amendment bill and the proposed amendments. I don't want to take much time on sort of introducing any more on the topic as such, because a lot was also discussed by our esteemed inaugural session panelists, and especially the Honorable Chairperson who spoke about the bill and what are some of the more important amendments that we are all keenly looking at. In fact, what we propose to discuss in this panel is some of those amendments, starting with the settlement and commitment regime, also talking about limitation, the concept of leniency plus, etc. So without wasting time, and I'm aware that we are also running behind schedule, maybe I'll first like to invite our session chair, Ms. Jyoti Jindgar, to just take us through the CCI journey so far. She's worn various hats at the CCI. She's seen and been an integral part of the growth of the whole enforcement regime in the commission, and maybe some words from her on, and some statistics probably for the audience on how the CCI has come so far and what has been the achievements, and some words on the amendment bill, ma'am.
Thank you so much. Dignitaries present today, eminent panelists. It's indeed a pleasure to be here, and particularly to speak on a topic with which I have been associated for more than 10 years of my professional life. And I have been fortunate enough to witness this journey and how the competition law enforcement has evolved over the years. So before I talk about the amendments, just a little background about this enforcement journey of CCI. So in over last 13 years, CCI, particularly in the context of the anti-competitive agreements, because that's the focus area of this particular session. So in last more than 13 years of its journey, CCI had occasion to examine agreements across sectors, different kinds of agreements, and agreements which are of diverse nature, both in terms of their impact, the kind of parties between whom the agreements were entered, the tenure of the agreement, and so basically the approach of the Commission has always been to keep into mind the specificities of the sector involved, the intricacies of the arrangement, the inter se relationship between the parties, the impact on the market, and within the overall framework. So the approach of the Commission has been that this being an economic law, to apply the principles of economics within the overall framework of law, and also Commission through its decisions and also based on recommendations which has been issued from time to time out of the market studies which have been recently carried out. Commission has been laying down the various boundaries within which these agreements are expected to be entered. And I think in that sense, it has been providing a lot of clarity to the stakeholders, because as we all know, the definition of agreement in our law is very wide, and also there are legacy issues, and the agreements are diverse, dynamic in nature. So to my mind, this has been a very useful exercise for all the stakeholders. And as we all know, now the markets are increasingly being digitized, and with that, a slew of novel issues have come, including in the way now the agreements are being entered by the parties. So we no longer have binary, only horizontal or vertical arrangements. There are novel arrangements which are revolving around the ecosystems. There are parties who are present across the ecosystems. So those arrangements which could be within the intra-group arrangements. So all these agreements now perhaps have to be examined from a different perspective, from the competition viewpoint. And that is where this amendment of the proposed amendment can be said to be very timely, because amongst other things, it proposes to enhances the ambit and make it all encompassing, because earlier at least it was felt although Commission has been also relying on the omnibus section 3.1 to look beyond horizontal and vertical agreements, but that has been an area of debate. But with these amendments, with the catch-all introduction of other agreements, I think it will really strengthen the hands of the Commission to examine other kinds of arrangements which are likely to come with the advent of the digital markets. Also, on the procedural side, I think the amendments have brought in several very significant measures. First of all, the leniency plus regime. And here, our past experience in the context of cartels has shown that leniency has been a very useful tool. In fact, almost out of 70% of the cases where a contravention was held in case of cartel matters, it has been uncovered on the basis of the leniency applications. Now, with the introduction of the leniency plus regime, I think this will further strengthen the hands of the Commission, and also it will incentivize the parties in coming forward and disclosing their knowledge about any other cartel which they may be aware of. And I think this is going to take forward the trust-based regime, which our experience has shown has worked really well. Then another important aspect which is in the form of settlement and commitments, which of course will, in the context of agreements, apply to other agreements other than cartels, because it is felt that for cartels we already have to some extent mechanism in the form of leniency regime, but for other agreements, the settlement and commitments, I think, is going to be a very, very significant change. Also given the fact that many a times it's possible that in their commercial arrangements, the parties may not have understood or realized that actually they are transgressing the contours of the law. And therefore, this will again enable faster market correction and a very trust-based regime where parties would be able to come forward with solutions and can move forward in life. So I think we are at a very critical juncture where the bill has now been referred to the standing committee, and it is very appropriate that we all apply our heads together and see that how going forward this will be operationalized. And I'm sure with the galaxy of panelists that we have here and their vast experience, they are going to provide insights into these new areas which are proposed and will provide inputs for the regulator. Thank you so much.
Thank you, ma'am, for that insight. And you're right, I think all these amendments are a welcome change. With the change in times, I think the need has always been felt to come up with new concepts which are able to help the industry more. The chairperson rightly said it's about ease of doing business, and none of these amendments are going to look as an additional burden on the industry. So I think moving on, we've tried to pick a few of these amendments for a detailed discussion. Maybe I'll move on to our esteemed panelist, Mr. Shekhar, who's a director with the CCI. I think Shekhar also has worn various hats at the CCI. He's a senior member at the commission, and we would really want to hear from him on his perspective or his views on the introduction of the settlement and the commitments regime, and how you see that as likely to reduce the litigation and maybe also increase compliance with law.
Thank you, Sagar. Pleasure to be here. And thank you, Jyoti ma'am, for setting a good background to the settlement and commitments, to the theme of the session. And I would like to start with what Honorable CLRC member Dr. Harshvardhan Singh said. Time is the essence, and the problem lies in the time period. And that within that time period, the problem needs to be solved. I think this sets a very good background for the settlement and commitment. So unless the problem is identified and solved within that particular time period, then the problem, even if it is solved after a number of years, then the problem cannot be said to be rectified in a true manner. So in this, I would like to point out that I have spent a number of years in the combination division, and I noticed that while in the combination division, a number of measures have been taken to cut short the procedure. For example, regarding the offering of the commitments, regarding the offering of the remedies and the modifications, earlier there was not any procedure to offer the remedies, modifications to the commission by the parties to the combination. But realizing this particular lacuna, the commission amended the regulations and introduced amendment to the combination regulations by giving an opportunity to the parties to offer the remedies while the combination is in the hands of the commission. So that basically cut short a significant time period, significant procedure, significant steps for the parties so that they can then have time available to devote their resources on number of other things. So I think it is in this background that the settlement commitments operate. Although there is a bit different that one is the ex ante side and the other is the ex post, but the basic theme in the of these two are same. So now coming on to whether this settlement commitment are we is this something very new to us? No, we have already dealt with in the form of the cutting of the procedures in the combination. We are a number of authorities in the world, they have already implemented these procedures, these mechanisms. And I would like to say that on the basis of whatever there is in the public domain available, that EU, for example, they have closed approximately 60% of their non-cartel antitrust by way of commitment decisions. Similarly, the DOJ and FTC, they have also resolved a significant percentage of the cases through the consent decrees, which are very much similar to the commitments. And another thing, in terms of whether they have really cut short the period, the Belgian Competition Authority, they have reduced their average duration of the procedures from 36 months to around 22. And similarly, the European Commission, in case of European Commission, it is noted that the average settlement case takes around 2.5 to 3 years compared to what was around 5 years in the ordinary procedures. And similarly, in case of Italy, nearly half of the cases, they were resolved by the commitment decisions. So international experience and the statistics also, they kind of support that these mechanisms are an important thing to cut short the procedure and increasing the procedural efficiency. Both these two procedures, settlement and commitment, they operate in separate spheres. However, the broad objective is the same, which is to put an end to the antitrust proceedings. The criteria applied is, while deciding if to accept a remedy or commitment, are the nature of infringement, the nature of commitment offered, and whether what is the ability of these commitments offered, they can quickly and effectively solve the competition concerns. So the emphasis all the way is on the increasing the procedural efficiency. The moment the efficiency is increased, everything comes to the halt, and then I would like to say that the moment the procedural efficiency is increased, we have number of resources available to the parties in terms of the time, in terms of the litigation that they have to carry out. So these procedures, they increase the efficiency, and therefore they are in the interest of the industry. They are for the benefit of the industry. They are for the even increasing the time period or the resources available at the CCI as well. So with that, I would like to say that yes, with these settlement and commitment procedures, the litigation will decrease, and in terms of the resources, and also that the number of resources available with the parties, with the industry, they will also be saved.
Thank you, Shekhar. I think you made a valid point, and of course, with every new introduction of a new concept or a new change in a law comes a lot of uncertainties and maybe how this will work in practice. So I would like to now move on to my colleagues from the bar on the panel here, starting with Abdullah Hussain, who's a partner at DSK Legal. Abdullah, of course, you heard Shekhar talk about the regulator's perspective on how the settlements and commitments regime is going to enhance compliance and also reduce the time of litigation. From a practitioner's perspective, what do you think would be the incentives for the parties to come forward and comply or admit to to this new regime?
Right. Thanks, Sagar. I think the most important factors will be two. One, whether there is an admission of guilt required when an applicant goes for a settlement or goes for commitments. Obviously, if there is an admission of guilt requirement, then that's going to reduce the incentive to go for these sort of schemes. Without an admission, it's likely to be a higher incentive. If we take the example of SEBI, I think one of the reasons why the settlement process that SEBI has in place has worked so well is exactly because there is no requirement to admit that they have contravened any of the provisions. So I think that's one major factor that will play a role in deciding whether to go for a settlement or a commitment. And second major factor, I think, will be the certainty that this will bring an end to the proceedings. So after all, why should any party go in for a settlement or a commitment? You want to bring an end to all the proceedings. We don't want a situation where after applicant has settled the matter, that he is again faced with legal proceedings, say for example in the form of an appeal. This could be by the informant perhaps, who is not happy with the settlement or the commitment that the commission has agreed to. So I think it's going to be important to have the informant as part of that process. And it could also be from third-party applicants, right? From liability in terms of compensation claims. And in that context, I think confidentiality will play a very important role. CCI is very cognizant of this. Even in their leniency regime, they have taken steps, and in the public version of their order, a lot of information, detailed information and evidence is usually redacted. So I think confidentiality also is a key aspect that they will have to keep in mind, so that we can bring an end to the legal proceedings. We don't want the applicant to think that, oh, this is just the start and I'm going to be faced with more liability going forward. So I think these are two very important aspects. Third, of course, the settlement amount. I think the CCI is going to have to come to a reasonable amount. If the party feels that it's going to spend or be saddled with a settlement amount that is almost equal to what it would have faced in a penalty, then obviously that reduces incentives to come forth. So I think these are the three major factors, the first two being the most important.
Bharat, what do you think about how, maybe, of course, Abdullah mentioned about there being a possibility of an admission of guilt. Do you think there will be a final order that would be passed? What are your thoughts on how the compensation claims would work in such cases? Of course, if there's an admission of guilt, then you are liable to a much larger litigation at a different stage. So what are your thoughts on that?
So I think, as Abdullah mentioned, it's $1 million question, whether there will be admission of guilt or not. Because, of course, if it's a without prejudice sort of settlement or commitment, then I think more lucrative for the parties to come forward. But of course, one important point to note is, of course, when a party is going for a settlement or commitment, filing the application, the CCI has not applied its final sort of application of mind is not there in terms of whether there is actual real contravention or not. And of course, the law says as of now that there cannot be any appeals filed against such compensation or settlement applications. However, compensation applications are filed under a different provision, and therefore, which effectively says that parties can go and any stakeholder, in fact, or an aggrieved party can go and file for compensation on the basis of the directions of the commission. Now, therefore, if the directions or observations of the commission is that there is actual contravention of the law, and to that extent there is an admission of guilt, then compensation applications can perhaps be filed in such cases. But of course, as I said, there's no clarity at the moment. Now, my personal view, of course, would be that it will be counterproductive for these applications to be filed on admission of guilt basis, because if we have to look at, for example, the leniency regimes across the world, and there's always been debate on whether leniencies are success or not in terms of the number of applicants actually coming forward. And one of the assessment that any party does before it goes in for an application is the cost-benefit analysis of what will be the cost of going for a leniency, what would be the cost in terms of compensation, and then take a judgment call on whether it makes sense to go for a leniency or not. I think therefore for us to achieve the full benefits of what we seek to achieve by settlement and commitment, I think it will be best if this is done on a without prejudice basis.
I think again there are a lot of questions right now more than answers, because I think with the development of the regime we'll see how that works. But we have an expert from the US joining us online, Jeremy Robinson, who's a partner at a law firm Gibson Dunn, joining us from Washington DC. Jeremy, would you like to share your experience with us on how the settlements and commitments regimes have evolved, and whether this has assisted regulators globally in general about in closing the investigations? And another question probably would be, what do you foresee as challenges in introduction of such a regime for a regulator like India right now?
Let me start by saying thanks to everyone, including the ASEAN leadership, for the opportunity to participate today and offer some perspectives from outside the legal community. I think generally, view is that settlements and commitments have been successful in all of the jurisdictions that have adopted them, for many of the reasons that the panelists have already shared. I mean, efficiency is a key one. All the enforcers have a finite amount of resources and have to make hard decisions about what cases they're going to pursue. And these more efficient resolution procedures allow more cases to be done with the same amount of resources as the enforcers. Also, we get competitive conduct addressed more quickly in the market. As you've heard, these processes can be years faster than the traditional resolution processes. So if there is anti-competitive conduct happening in the market, this process allows it to be addressed much more quickly. Also, there are obviously enormous differences between the jurisdictions and how this has been operationalized. And I think that's going to be a real challenge for the CCI as they think about what process they want to adopt and what the regulations are going to look like. And that in large settlement ultimately isn't looking like it will be advantageous. You need to also think about when settlement will be available, whether it's something that can be done by right, or whether the CCI wants to preserve its discretion to think about when settlement will be available to the parties. I know the European Commission has decided to maintain that discretion for itself, and parties have to await the Commission decision that they want to allow settlement in a particular procedure. That's very different from DOJ in the U.S. here, for example, where any party can approach the DOJ at any time to explore the possibility of a resolution. I'll say one of the biggest challenges, I know the CCI has already faced this, I'm sure, in looking at merger transactions, is once you've been successful and you have secured a number of commitments or settlements with companies, you then have a significant back-end enforcement obligation that will consume a lot of resources. And as you are successful, and as more and more of these commitments are on the books, you need to ensure that you have the staff in place to enforce them and monitor compliance with them. I think in the U.S., we have seen DOJ increasingly interested in bringing in third-party monitors. They can ensure the company is remaining in compliance and take some of that burden off the enforcement agency. But it's definitely something to think about early on before, obviously, the resource demands of all of the past resolutions have built up. And then just one final question. I think it's not currently entertained in the amendments bill, but it's the question of whether or not settlements should extend to cartel cases. I know in the U.S. that's the case. In Europe, that's the case as well. And those cases can go on for many years, especially for all of the parties that leniency wasn't an option. And offering a path to a settlement in the cartel cases can introduce the same type of efficiencies that you're discussing here in some of the non-cartel conflicts.
Thanks for that perspective, Jeremy. I think a few valid and some interesting thoughts from your side, and I'm sure the Commission's looking at the advanced jurisdictions on how to formulate the regulations, because there is that power in the proposed bill at this stage to how these regulations will form and what are some of these questions that we've looked at will probably be answered, and we'll see how that comes about. But no, thank you so much. I think moving on from this topic of settlements and commitments, I think another interesting observation and one more important amendment that the Honorable Chairperson also talked about was the limitation period. I think in addition to that, we are also talking about the leniency application in general, the provisions and the changes towards the leniency regime. One important proposal is the power, the option to an applicant to withdraw a leniency application. Moving on, maybe I'll put this question to Nilambra. Nilambra, do you think this amendment in the current form, which suggests that gives an option to an applicant to withdraw the application, however, at the same time, it gives the power to the DG and the CCI to use that information against minus the admission. What do you think, how would that work, especially for a party who will later on want to defend such allegations?
Thank you, Sagar, for that question. It's a very interesting amendment that is being proposed here. So the whole idea of leniency, such as, and the same is with settlements and commitments, is that a party is trying to analyze its risk, its cost, and the time benefit versus risks that are there. So therefore, this is another way for a party to be able and to have the flexibility to roll back, being in a process that it has committed to. Because earlier, or in the present regime, once you put in your leniency application, there is no way to roll back from there. And then you are stuck in that system, and it is up to the CCI to whether grant you leniency, whether to grant you penalty reduction or not. There is not so much that the parties can do. Having said that, this will allow parties to be able to, at a stage when they have probably been sort of coerced into, or sometimes because the way cartels operate, you see one has gone in and you feel that, it is good for you to at least get your marker status. So you go in a rushed manner, you haven't done your risk assessment, you haven't tried to really see, and of course you don't have the information about what, this leniency is really about, whether your case is distinguishable from another party who has gone for the leniency. So when at a post-stated state, once you have sort of put in the application, but you come back and you do that assessment and realize that maybe my case is not fit for this process, and I, in fact, have a better chance of defending myself. So parties now will have that flexibility. Now, coming to your question, really, what happens when you are voluntarily giving information to the CCI, and there is the admission that also goes in. So to my mind, this would really depend on the stage and the quality of information that has been given. So of course, if it is at a significantly later stage, where a lot of information has been already provided, I don't see any benefit to a party for rolling back and withdrawing their application. But if it is at a very premature stage, where there may be some sort of an admission, but the kind of information that you have already provided is not going to prejudice you completely, then you do have the ability to defend your case at a later stage. Because in a cartel, there is a presumption of guilt, and not very successfully, but at least the parties do have the option to rebut that presumption. So it would just lead to probably more interesting litigations emanating from leniency in the future.
I think the idea is to reduce the litigation. So, Bharat, any thoughts on that? Anything you want to add?
I mean, just one thing. I think Nilamana is right. I think one is that how many parties would have an incentive to then withdraw the applications when they filed it. But I think an important question, therefore, is that parties have to be more circumspect going forward in terms of when they are, and once they get inside and sort of file the application, you have to do it with a little bit of more seriousness and certainty, because in situations where you decide to withdraw at a later stage, where you're just trying your luck, the same evidence can go against you. Of course, there's no admission, so to speak, and there is always a presumption which you can rebut. But at the same time, of course, this seems like two conflicting themes. So, and therefore, I think the bottom line is that parties have to be more serious about, and look at it carefully before they actually file an application with the CCI.
Maybe at a marker stage, one probably rushes in after a raid or something, and then suddenly realizes that maybe it's a defensible case, then they could probably withdraw. No, thank you so much. Another interesting change is the introduction of the concept of leniency plus. So on that proposal, maybe I'll ask Shekhar to share some thoughts on this proposed addition, and how do you think that it will impact or benefit the already existing leniency regime, which also ma'am said has been quite successful. Your thoughts, please.
Yeah, I'm again saying that the leniency regime that we have, that have been implemented by the CCI, has been a successful one, and it was in 2017 only that we came out with the first decision of the leniency, and today, if we see that we have received more than 100 applications, leniency applications, and in all those cases where have been an order of under section 27 has been passed, around in more than 70% of the cases, the cartel members has come forward as the leniency applicants. So it is quite evident that the leniency regime that have been implemented and implemented by the CCI has been a success. So now with the introduction of the leniency plus regime, so another add-on to the incentive to the parties to come forward to offer and to come forward with the evidences or information about the cartel which is operating in another market or another area, which can be a different geography altogether, or it can be a product also. So leniency plus regime basically is basically deals with the multi-product markets or the companies which are dealing in the multi-geographies. So with this leniency plus regime, the another incentive has gone to the parties to disclose the information about the other cartels. So here again, the parties will have to factor in the risk basically. So if it is already part of the cartel and it has not got any lenient treatment so far, then it can again evaluate its own course of action for the future, whether it can come, it wants to come to disclose the cartel in the other markets, say cartel in the cartel B. So with this, I think not only the deterrence to deterrence for the cartels will increase, but also that the consumer welfare, because with the reduction of the cartels in the economy, the consumer welfare is going to increase, and again with the consumer welfare, the efficiency will increase. So this concept is a new one to our country, but it has been implemented so far by EU and other international jurisdictions, and been a success so far. So with that, I will say that yes, this leniency regime is going to benefit to the economy and to the consumer at a large. Thank you.
And maybe at that thought, Jeremy could probably add in here, because US has been it's been a long-term feature, this concept in the US regime. Maybe you could enlighten us on how that has worked so far, and maybe also a bit of thought on whether there's this option of withdrawal of a leniency application in the jurisdictions that you've worked out.
So, leniency plus is interesting because it's been part of the U.S. leniency program now for almost 30 years. But it's an area where there's been a lot of convergence internationally. And so, if you go, for example, if you look at the European Commission, they've not adopted a leniency plus regime. But our experience here in the U.S. has been, I think, quite positive. If you look at the major international cartels, I'm sure everyone in this room has worked on some
No, thank you so much for that perspective, Jeremy. Sorry, we've been requested to sort of close the session because we're running behind time. But there's that last topic on the limitation period that I would really like to talk on. Maybe quick points from Nilamra and Abdullah on this new proposal, and also, as I said, the chairperson spoke about it, is the introduction of the limitation period on filing of information. Would you think that help will avoid frivolous and time-barred litigation, and would it also probably impact the right of an informant to approach the CCI, maybe even if he's late?
Right, so like the chairman has already indicated, it is a positive move. It would keep out certain levels of frivolous litigation in the future. I think this would really work, especially in certain kinds of cases. So let's say in dynamic markets, where let's say a particular technology is already in disuse, and somebody decides that today I want to initiate an investigation against Sony for abuse of dominance in the CD-MAN market. It makes no sense for the CCI to even look at it. So the time bar itself would keep out such litigation. Of course, my example is very extreme. There could be certain more recent technologies which could be in question. Similarly, in cases of public procurement, bid rigging, somebody is bringing in a complaint about bid rigging in a certain single or two incidents which happened in 2010. Those tenders have been cancelled. Would it make sense for the CCI to look in? Probably not so much. But the issue that I really see here is, while India as a jurisdiction has limitations in most of the spheres, and we have a limitation act which applies for other civil offenses. Unlike other civil offenses, the Competition Act is in rem and not in personam. And the issue of when the cause of action arises would be a big challenge for an informant to establish. Also given the fact that this is an informant-based regime and not a complainant-based regime. The other issue that I really see is that the 3-year limitation starts from when the cause of action arises and not when the cause of action ends. So will it be possible for an informant, or will the informant have enough information to establish when the cause of action arose at all? And also, is 3-year a very short period of time to close that limitation gap, is what the questions that are there in my mind.
Abdullah, maybe your thoughts on this?
Yeah,
and
very
also,
quickly, because I'm cognizant of the time.
No, but also I want to hear from you if you want to add a couple of thoughts also on the leniency plus regime, if from an India practitioner's perspective, sure. After of course this control.
So let me address limitation first. I think it'll be a useful introduction right now, both for industry and for the CCI. Right now, the CCI doesn't have that kind of discretion to close matters just because it is pertains to conduct that may have taken place over a decade ago, like the chairperson also said earlier. So informants are going to have to be a little more attentive, proactive, but none of this will again affect the ability of the CCI to go back beyond that period of time. I don't think that power or discretion is taken away from the Commission. So I think just a few days ago there was a decision of the CCI related to a cartel in railways tender where the conduct went back to 2015. I don't think that ability will probably be affected. Although if I was on the other side, I would say that that is implicit and argue, which I'm sure will also be rejected, but I must try. Sorry, you had a second question.
Just some thoughts on the leniency plus regime, if you want to add something.
Leniency plus, I think, has been fairly addressed by Shekhar and Jeremy as well. I think it's definitely a good introduction, something that the CCI has once or twice in the past already sort of implemented in a way. If you see the Pune Municipal Corporation cases, I think where one of the parties to one of the matters did disclose information about another related cartel, and they were given a higher reduction in penalty. So something that's already working and will definitely be useful.
Okay. Well, thank you so much. And that was all that we had for this session in terms of the questions for the panelists. And thank you all for sharing your valuable insights, and thank you, ma'am, and Shekhar for sharing the regulator's perspective. Thank you, Jeremy. It's a very odd hour for you, but you look really fresh. And thank you everyone. I think we'll all have to wait for what happens in terms of the Parliamentary Standing Committee's views and how the law is finally the shape. But these are all welcome changes, and we all look forward to seeing this codified in the future. Sure.
Just for the concluding remarks. So I think overall the consensus is that the new proposals are very beneficial, and they will, I think, go a long way in achieving the objective of a faster market correction. And all the points which have been made today are very valid, and in some sense as a regulator we have the advantage that some of these concepts have also been tested by other regulators and in India as well as in other jurisdictions. So we would keep those in mind, and also the specificities of our country and how the incentives need to be aligned. At the end of the day, we want workable mechanisms and which are able to achieve the end objective. And definitely, as in when these are enacted, I think stakeholder consultation is really going to play a very key role in ensuring that everything is addressed and we come out with a workable solution. Thank you so much.
Thank you everyone.
Well, thank you very much, Mr. Rathi. I'd also like to extend our heartiest, sincerest gratitude to Ms. Bhanot for chairing the session. I'm going to very quickly request Mr. Karan Singh Chandiok to give a formal vote of thanks for this session and also present a memento on behalf of us here at ASSOCHAM to the session chair and thank her.
For the remaining panelists, I want to say it's not austerity measures that your memento will reach your office. We're just conscious of time. So thank you so much for this great panel. It was really engaging, and at ASSOCHAM when we've spoken about settlements and commitments, all these issues that have been raised are something which has been important to us as well, including the fact that when this regime does come into place, it's important that there is a window, maybe 6 months or so, where even existing cases which are under investigation may be given this opportunity to take benefit of this regime. A very special thanks to Jeremy for joining us at 3 a.m. in the morning, all the way from DC. And we look forward to having you in person next time when we do this conference. Thank you so much for this panel. Thank you.
Well, thank you everyone. As we capture this moment and keep it with us forever, I'm going to request everyone to kindly remain seated. We are going to head next to our technical session 2 on M&A and the Competition Amendment Bill, the 2 steps forward. That's what we're going to be discussing. The discussions are going to revolve around, of course, various changes that have been proposed in the merger regime and implications for business, the gun jumping deal value threshold, penalty on misrepresentation, DVT, sector specific, and interplay with de minimis. So I'm going to request everyone to kindly remain seated. Like we have said, we promise you time and opportunity for networking.